behalf of Clue for Evidence, welcome everyone to our DHI 36 Expert Talks webinar series. Our today webinar topic is Forensic Report Writing Standard Practices and Legal Significance. Our today's session speaker is Mr. Pavendra BN, Court Commission Forensic Expert and Director of Clue for Evidence Forensic Lab, India. He got appointed as a court commissioner by one of the Honorable Law Court. From then, he is being recognized as a handwriting expert and appointed as a commissioner to the court in many legal cases. With an intention to provide the best professional services in the field of forensic document examination and private investigation, he became the co-founder of Clue for Evidence Foundation, which is an organization of a fraud and risk management solution in the relevant fields. Over 4,500 report issue and several cross-examination attended, because of which the session was chosen. Now I hand over the session to Mr. Fernandez, sir. Now the session is yours, sir.
Thank you, Archana. Thanks for your introduction about me. And yes. Good evening, dear participants. And I'm very glad that, I'm addressing the audience on this exclusive topic, which has been one of the most requested topic so far, because whenever we discuss about the forensics and its reports, I was suggested by different experts and different academicians that, there should be one session on how to write the reports and what kind of reports are to be expected by the courts. So with this, inputs, so today I'm presenting with you the topic on forensic report writing and the legalities and the technicalities as to what should be mentioned in your reports and how your reports are to be maintained. So the first thing I should be doing now is to broadcast the screen. Okay. Yes. I hope my screen is visible to the participants. Slideshow, okay. So first of all, in this session today, I'll be covering the topics related to the importance and significance of the forensic reports. When I say forensic reports, I do refer to the legal requirements. That is the first thing. Okay. In the meantime, we also discuss about the different parts of the forensic reports. When I say different parts, there are various elements which are to be included in a forensic report. So we will discuss about that, and the significance and importance of the photographs in the report, that will be discussed, and the language in which you try to communicate your findings to the court or to the other person. Okay, the importance of that. Okay, with regarding the simple language versus the technical content. So that will be discussed. In addition to the references, and we'll also discuss about the questions if you have any. First of all, we need to understand the forensic report and its significance, where the forensic report summarizes the substantial evidence in a case, and forensic report may prove difficult in daunting because it usually demands analysis of technical data. See, this technical data is presented in a readable and easy to follow format. See, first of all, the forensic report has a term to be explained. Forensic being the branch of science which deals with the investigation aspects. Definitely, it should be having the reasons with the technicalities, and it is definitely a scientific aspect. It should have procedures and the observation part of it, what you have done. So with all said and done, it demands, the word is used here is the demands the analysis of technical data and presented in a readable manner and easy to follow format. So this is a very gist of understanding about how your forensic reports should be, or how the reports are to be expected. That is the simple understanding about the forensic reports. When we discuss about the forensic reports, we should also discuss about the forensic experts. In our legal dictionary, there are three important provisions which specifically discusses about the experts, who is the expert and which kind of people can be considered as the experts. So when we discuss about this, so there are three important provisions. One is the section 293 of CRPC, one is section 45 of Indian Evidence Act, and another one is section 79 of Information Technology Act. These three sections which actually explicitly defines the provisions of experts and the significance of the reports before the court trial. For many of us, forensic reports, see, for example, the forensic students for that matter, unless and until you have been to the court, unless any forensic expert have been to the court to depose before the court as an expert, they really don't understand the purpose, the critical purpose, the whole purpose of the report writing, because most of the situation, people try to act as technicians of the lab. When I say technicians, you sit in your lab, okay, you just prepare a report and you're done with it. But when the situation demands that you have to go and justify your report, that is something which actually makes you as an expert. Everybody can be technicians, but everyone cannot be the experts. Because even if you do the best of the best report sitting in your laboratory at your desk, if you don't know how to go before the court and justify your report, you are no good as an expert. So expert is someone who can prepare the report as well as to justify the findings, his findings before the court, whenever and in whichever manner the questions are posed to the expert. That is what actually makes him as an expert. Otherwise, everybody sitting in the lab can prepare the reports. So this discussion is not just about sitting in your desk and preparing your report. I mean, preparing a report and sending it to the court or giving to the client. Nobody asks you about it. But when you go to the court to justify, that is when the significance of your forensic reports play a critical role over there. So with this, a brief discussion, the three provisions which discusses about the experts and their category. What it actually refers as a duty of the experts. When we discuss about duty of experts, experts are definitely one of the category of witnesses. And in witnesses, there are different categories. When one can say eyewitness, one can actually consider something as corroborative evidence. Okay, so witness evidence is different, a corroborative evidence is different, and expert evidence is going to be different. And every category of such evidences has its own pros and cons. But the duty of the expert when we're discussing here, we have something to do very similar to the role of an advocate in the case. Because to a certain extent, both the professionals, the advocate as well as the forensic expert, are usually considered as officers of the court, or both of us has a duty before the court to represent the case in certain manner. But in only one regard, how we differ from the advocates is that for an advocate, there is a obligation, a professional obligation, that he has to support his client only. Even though he knows his client is not a good person, or he is actually a person who committed the crime, the advocate who takes the particular case has an obligation to plead before the court on behalf of his party. But a forensic expert will only differ in this regard. However, he also submits his report, he also shows whatever he wants to show. But his first duty here is an expert is not a witness of fact. When I say witness of fact, how can you be a witness of fact? Is only because when you have seen something, you are a direct witness. When you have heard something, you are a direct witness. When you have perceived something, you are a direct witness. But the expert here is not a witness of fact. He actually giving his evidence is of an advisory character. When we say advisory character, see, if we just go with the real-time situations, let's take the example of International Court of Justice, ICJ, where any disputes between the two countries, okay, would be heard before the International Court of Justice, and their judgment does not bind the respective countries to strictly follow the particular orders. Their judgment can be considered as advisory in character, and that particular judgment, the respective countries has a choice to make whether do they want to follow that particular judgment of ICJ or not. See, by following, they will have a different results. By not following, it might result in some other repercussions. That's a different thing. But when I just give an example as to the expert evidence is a advisory in character. When the advice is given to anyone, the person who receives the advice is not obligated in all the situations to strictly follow the advice. He has to take the advice, he has to assess the situation and do his calculation and then give his judgment. So in this regard, the opinion of experts is an advice to the judge or to the court. That's an advisory in character. An expert deposes and he does not decide. And who will decide? Decision is made by the courts, honorable courts. And the expert will only mention, he only deposes and he only state what is being asked for. He only answers what is asked for. And he does not decide anything. So for the same reason, in most of our reports, we try to avoid using the words, the signature is a forgery. Probably we use the word, the signatures in this case were observed not to be authored by the same person. Okay, that might interfere, that might actually infer the same meaning, but while using the word, we prefer not to decide on the whole thing. So in this regard, who will take the decision is either respective courts or the adjudicating authority. The expert only has a duty to depose and to give advice by the way of his reports only. An expert witness is to furnish the judge necessary scientific criteria for testing the accuracy of the conclusion, so as to enable the judge to form his independent judgment by application of the criteria to the facts proved by the evidence. So when the report is, see, what I'm discussing right now is the legal principles. I will then relate this to the scientific requirement. So we have to, while we are doing the forensic examination and doing the forensic reports, it's very important for us to understand how does the report be perceived before the court. So what I am discussing right now are the legal principles. So we have to meet up with this criteria before we submit our reports. That is the legal significance of the forensic reports. So, however, the expert witness is to furnish a judge the necessary scientific criteria. So, by default, forensics being a scientific, a field of scientific study of the facts and to science which deals with the investigation aspects, and the judge being the adjudicating authority. So, we should give the scientific reasonings to the judge so that the judge makes his independent decision based on the weightage you try to show in your reports. That's what the scope here is. However, there are two important things to understand here. The value of expert opinion in most of the judgments. Okay, there has been several judgments, which says the expert's opinion is not binding on the courts, or the expert's opinion should not be considered as a conclusive evidence. Yes, see, the provisions as per the law is good, and this only defines that the forensic experts has to be very sure in their approach. When you show that you're very sure in your approach and you show that reasons for the court to believe, there are also good judgment which says the court relies upon the opinion given by so and so expert in so and so case. So while we come to the legal weightage of the forensic opinions and the expert's opinion, there are good equal number of cases which has given the reliance on the forensic opinions and which has even criticized the reports given by the forensic experts. So depending upon the case, the respective citations would be used by the advocates. And By default, in law, there is always a precedent to be used. But your report would be used for what category of precedent is very, very important, and that makes a difference in your approach. First of all, the expert's evidence has two different aspects. One is the data evidence. It can't be rejected, and if it is inconsistent to oral evidence. See, the report given by the experts are discretion. The court has a discretion whether to consider the reports given by the experts or not, including the reports of the medical examiners. The court has the discretion whether to consider such reports or not. See, no category of experts' reports are binding to the court. That is one simple principle. The judge or the court will consider the reports of the forensic experts if in case that is in par with other facts of the given case. So for this, one category of evidence here is the data evidence, which cannot be rejected just like that, because when you go to the crime scene, when there is a knife which is used to kill a person, and which is the knife which is still over there with the stains of the blood, and that is a material evidence, and that need not be, that just cannot be rejected. And even though there is a report of the ballistic expert required for that, okay, that just simply cannot be rejected, and that can still be acting as a corroborative evidence. Okay, the fact that the person was killed by the knife and there was a knife which was found in the crime scene is a good piece of understanding for the court to go ahead. But in cases like this, they also seek the opinion of the ballistic expert if in case the same for firearm, the firearm or the weapon was used to commit the crime or not. So this becomes a fact, that there becomes a corroborative evidence that yes, the person died because of the knife, and there was a knife present in the crime scene, and that knife is again certified that this was the same knife used for killing the person. So this becomes a corroborative evidence. So second is the opinion evidence. It is only an inference drawn from the data, and it would not get precedent over the direct eyewitness testimony unless the inconsistency between the two is so great as to falsify the oral evidence. The opinion evidence is again considered, the court always says the opinion evidence has to be exercised with utmost caution. With all said and done, it is the opinion of an individual. The data, whatever is the fact, how the fact is interpreted becomes opinion. So it's a technical discussion altogether, but yet there are questions where whether the fact in your hand, whether the evidence in your hand requires a opinion, or this material itself can be proved as a evidence. So this depends on case-to-case basis, because when you find a recorded audio, for example, the audio says everything about an individual, and consider this audio is the last voice of a person who committed suicide. So here, this audio itself can be used as a material evidence, and depending upon the facts shown in the case, there might also arise that this audio needs certification under section 65B. How do you rely upon an audio without being certified? There might be chances where the audio has been manipulated. So it depends on the court consider the material evidences and its suitable opinion to the given case. However, the opinion evidence, if in case it goes along with the eyewitness or other circumstantial evidences, that's a good piece of evidence. If the opinion evidence alone shows something against the direct eyewitness testimony, so this need not be considered by the court is what the legal principles are. So for this reason, why we are discussing about the forensic reports and the legal principles is because if in case your report does not meet up such quality, such standard to make the court to rely upon your report and to really consider the actual facts of the case, technical approach to the actual facts of the case, there is no reason for the court to really look into your evidence or your report at all. It's only when you demonstrate that, yes, there is a strong reason in my report that the entire fact of the case might be looked in a different manner, only then the court will be obligated to look at your evidence, or you will look at your report, is what the legal principles are. And this also is supported by various judgments of different courts in the past. And whenever the court passes any judgment, that judgment will be used for several other cases, unless and until this particular judgment will be set aside by any higher courts. Okay, so for this reason, it's very important to maintain a good standard of the forensic reports. And probably when you see the courts today talking about the reports are not conclusive, or especially handing expert report are very weak evidence kind of a thing, this only makes you understand that the people who gave the report in the past, okay, in that particular case, did not meet up to the technical standards or the legal standards of report writing, because of which court actually cited this report of handling experts need not be binding or need not be used as evidence in the case. That particular finding of the case has been used in several other cases. And today we have reached a situation where the advocates consider the expert opinion is just nothing. It's just a simple piece of evidence that can be contested, that can be, that is not binding on the court. So this doesn't happen for all the category of evidences, but yet there are a few category of experts who come into this category of criticism. And especially in this regard, the fingerprint experts and the handwriting experts are the ones who are been most criticized in this category of citations. We have to understand two things here. One is the fact, one is the opinion. So on the screen, what you can see is the fact is a statement that can be proven true or false. So it's just a fact remains facts anytime, anywhere. That's a simple understanding. Okay, a fact can be proved as truth or false also. But an opinion is an expression of a person's feeling that cannot be proven. This is a simple dictionary explanation, but opinion can be based on facts or emotion, and sometimes they are meant to deliberately mislead others. So for this reason, for this dictionary meaning of the opinions, the expert's opinion, especially with regard to handwriting, has been always criticized. Therefore, it is important to be aware of the author's purpose and choice of language. Sometimes the author lets the fact speak for themselves. So this explanation actually covers two things. One is the opinions can be based on just their emotions, which might not be logically justified. But on the otherwise, sometimes the opinion are such category of expression where the author lets the fact to speak for themselves. So ultimately, a person who is trying to show something before the court, how you are going to show before the court makes the approach as a fact or as a illogical opinion. So this is something which is a challenge before the forensic experts as to how your reports should be. So can you make the facts in your report to speak for themselves, or are you making an impression that it is my opinion, which is not justified, but it is my opinion, that's it. Even though I see signatures being very similar, but yet I say it's not similar. It is my opinion. So do you want to say like this, or to demonstrate, to give such logical reasoning, scientific understanding, so much so that anyone who looks at your findings would be convinced to only say, yes, the conclusion is the only thing which I also understand. So this actually is a challenge and an art before a forensic expert. What it says under Section 45 of Indian Evidence Act, why I am discussing about this section is because several other provisions, several other experts of different categories, there has been some kind of immunity, and there has been some kind of legal flexibility and legal provisions for them to, not to present before the court for deposition, or the reports of certain government, experts are considered as the evidences. With all certain done, yet we have one important section where we are discussing about the handwriting experts and fingerprint experts specifically. So when the court has to form an opinion upon a foreign law, science, art, or identity of handwriting or fingerprint impressions. This is what the explanation given under Section 45 of Indian Evidence Act. And for everybody's understanding, Indian Evidence Act was enacted in 1872. We are following the principles established in 1872. In those days, there was no full-time university or any full-time course available for the examination of handwriting or examination of fingerprints, for which this particular experts were categorized under Section 45 of Indian Evidence Act. So here the expert opinion is only corroborative evidence. You need to understand this very carefully, because the expert opinion is expert opinion is only corroborative evidence. It must not be the sole basis for conclusive proof. This expert opinion does not only limit for Section 45, but it also applies for all the category of experts. The expert witness must be subjected to the cross-examination in the court. Mere submission of opinion by an expert to any certificate or any other document is not sufficient. And this explanation holds good for Section 45 of Indian Evidence Act, because the person who submits the report with regarding the foreign law, foreign science or art, or handwriting and fingerprint reports, this people have to be subjected for the purpose of cross-examination, and their report alone, without the examination of the expert who gave the report, cannot be considered as a evidence, is what the principle says. That means by default, the experts of handwriting and fingerprint has to go before the court and depose before the court for the purpose of chief examination and cross-examination. When I say chief examination, it is examination conducted by the court or the advocate to whom your report was in favor of. So the court practices differs in different between the judges. Sometimes the judge himself, okay, does the chief examination, because sometimes the people who are engaged for the purpose of handling a fingerprint examination, they are considered as the commissioner to the court, and because the commissioners are appointed by the court, so the court examines the expert. So this becomes a chief examination conducted by the court. But in some cases, the court will say, see, this report is in your favor to one of the party, so you conduct the chief examination. So after the chief examination will be the cross-examination. Cross-examination is the one which is conducted by the advocate to whom your report is not in favor of. So in any forensic cases, by default, you will be subjected for the cross-examination, because not in all the cases, okay, your report will be in favor of both the parties. So you can only, your report will be in favor of only one person. Okay, that is very important. So the other person definitely will conduct the cross-examination by default. So this is the provision as per Section 45. And one important thing to understand here, whenever we discuss about the opinions of different experts might vary, and this has been a fact which we have seen in our proceedings as well as in different cases. Yes, there might be two different experts saying two different conclusions. In such case, what happens to the court? Court can rely upon which expert, and that is the question. This principle says that the expert opinion which actually favors the circumstances of the case, only that expert's report can be considered. That means the findings what the expert has given, one expert has given, the other expert would have contradicted that. In spite of court having two different category of reports, that means two different category of conclusions, court can consider the report of the expert, which actually supports the other facts of the given case. So what I'm discussing is also supported by the court judgments. Two questions which I'm going to answer very importantly in this. Can investigation officer be the expert? So when we discuss about this, the significance of the expert is such that the person who is investigating a particular case, even though he knows, so say for example, there will be a fire, arm which is seized from a crime scene, or even if it is seized red-handed, a person shoots a person. Okay, the police takes the revolver from the person by hand. Okay, and it is they are caught red-handed. In spite of that, in spite of the expert, in spite of the investigation officer seeing the whole thing, in spite of the investigation officer knowing that this gun or this revolver pistol was used to shoot that other person, still the opinion of the ballistic expert is very, very important. So the investigation officer cannot be the expert. He cannot form any kind of a document which says this bullet was fired from this firearm only. No, being an investigation officer, he can only seize the weapon, submit this particular weapon to the particular expert or the forensic lab, take the report, use this report as a document for the purpose of charge sheet. So the investigation officer cannot be an expert, and because of this, there's a significance for the experts. Next, can an expert suo motu examine and furnish his opinion? So I have always been stating this. Experts, forensic experts, don't have a suo motu provision, because we only answer the questions which are asked by the investigation officer or by the court or by the client. Whatever they ask us to mention is what we are going to conduct our examination for which forensic experts cannot suo motu. Suo motu is without being requested and acting on our own, initiating something on our own. So this provision is not applicable for the forensic experts. However, what it requires, see, out of the legal provisions, one important provision here is section 51 of Indian Evidence Act, which says whenever the opinion of any living person is relevant. So this is not just the experts. Okay, whenever the opinion of any living person is relevant, the grounds on which such opinion is based are also relevant. See, just I say something is not just relevant, but on the basis of what I am giving my opinion, that basis is also very, very relevant, is what this particular provision says. Opinion is no evidence without assigning reasons for such opinion. The opinion of experts also covers this aspect. So opinion is no evidence without assigning reasons for such opinion. There should always be a reason, and when we discuss about the forensic opinions, that is a scientific reasoning. That's what the understanding here is. The correctness of the opinion can be better estimated if the reasons upon which it is based are known. So you cannot just come and say for some reason. Those reasons should be in practice. Those reasons should be in place where they can go check, verify. This is what the provision in general. But as far as the technical or the scientific aspects are concerned, those reasons, whatever you mention, if in case the person follows the same procedure, the conclusion should remain the same. That is the reasonings what you're going to give in your conclusions. If the reasons are frivolous, what is this? Frivolous, okay, or inconclusive, the opinion is worth nothing. So this was just a simple understanding that if your reasonings are not having any scientific understanding, or if the reasons are not as per one's convincing factor, this reasonings cannot be accepted. That means your opinion is worth nothing. That means it can only be of zero value, is what the legal explanation given here. Going to the aspects of report. So far we discussed about the legal requirements as per how the court of law looks at your reports. But when we come to the report writing requirements, there are a few things which sometimes we don't mention, sometimes some other people mentions about it. But what is required in the reports is what I have listed here. One is the non-technical and documentation information. That is the first element of the forensic reports. In this, what is covered is the non-technical aspects of your observation, which means when did you receive the consignment, who communicated with you, when did one communicate with you, how did you receive the particular sample, did you receive by the registered post, or was there someone who came to deliver it to you, and what was the condition of the package, was it tampered, or was it good enough to consider it was not tampered, was the seal intact. So all these things we have to report in our observation. When we submit our forensic reports, these things are to be included in the observations. So that is the non-technical, because that is no way related to the technical observations at all, but it is important and relevant. How and when and who received it, all these things have to be mentioned. Second thing is the questions which need to be answered. So whenever you receive the consignment or the case in hand, the person who is requesting for the forensic examination would usually give the list of questions. Okay, this test results are to be reported. I mean, this questions are to be answered. Whether if the bullets are fired from the same revolver, okay, whether if the blood sample matches with the accused or not, whether if the signatures are signed by the same person or not, fingerprints belong to the suspect or not. So these are the questions asked by the court or by the advocate or by the investigation officer, whoever submits the case to you. That particular question needs to be specifically mentioned, and that should be specifically answered in your observation. Next, in your report, what are the procedures you have followed is very, very important. Because when we say scientific report, if in case the other person also follows the same procedure, what you have followed on same samples, the other person should also come to the same conclusion what you have reached. So for which the procedures what you have followed is a part of your scientific examination, because the way we write our record books, okay, aim of the apparatus which are used for the experiment, okay, the aim of the experiment, the procedure which are to be followed, observations which you observe, and then the conclusion. So however you write all these different elements in your record book, similar elements are to be reported in your forensic reports. So procedure what you have followed should be reported, and then apparatus what you have used. So if it is a specific or known category of the apparatus. So for example, for conducting the examination on the blood or DNA requirements or chemical requirements, these things are very set. Okay, people use GCMS, HPLC, all these things are known. So these things, they only mention the apparatus which are used. Okay, they might also say suitable apparatus for the testing of the blood or semen or whatever it is were used. In this category, the apparatus and procedure followed is not very, very important. But when we discuss about the fingerprint examination and the handwriting examination, these things are those which are questionable before the court in the cross-examination. What procedure did you follow? What are the principles did you apply? What are the apparatus did you use? So all these things becomes a very relevant point of observation before the court. Next is observation. Using this apparatus, using the following the principles, what other things did you observe? So this is the observation part of it, then the conclusion part of it. So how different? So additional to this, the forensic reports will also contain the suitable photographs wherever it is relevant. When I say wherever it is relevant, not all the forensic report categories do require photographs, but yet there are few which requires the photographs. In such cases, in olden days, whenever the photographs were taken, the negatives were supposed to be given along with the photographs, because it was the negatives which cannot be forged, is what the earlier generation was. But today, while we are using the digital cameras to capture the photographs, the soft copies of the images are to be submitted to the court, because the digital images would contain the image integrity part of it. So from which source you capture it? So what was the date, time we capture it, everything will be recorded, and that becomes a part of your report. So to submit the soft copies, you use the photographs in the report. Most of the reports, especially wherever the photographs actually act as a very important factor, what I have seen or what you can see in the general practice, this photographs does not come with the scaling part of it. Scaling in the photography is very, very important, especially when it is used in the handwriting examination. Because while you click a photograph, what is the actual size of the photograph is very, very important. What is the actual size of the signature? If in case you are actually using a photograph, and if you magnify that, that magnification will look like it occupies the entire screen. So for which the photography with the scaling is very, very important, and those reports which contains any photographs and there is no scaling in that can be questionable. And whenever you submit the photographs to the as a part of your report, be noted that the photographs are to be captured using different lightings, because there are few things which you only find in the oblique lighting, there are few lighting which you only find in the transmitted lighting, so there are few things which you can only find in IR, UV, and with different filters. So you have to capture the photograph with different lighting conditions, and in whichever the magnification you actually examine the samples, those relevant magnifications are to be recorded in your case sheet. But when you submit the file to the court, it's necessary and it is recommended that you include all those case related captures in the soft copy before the court. So you will not be asked a question as to why you have not submitted those photographs before the court. This will be very important in the cross examination. Next is the technical contents, how you are going to use the language to communicate what you have observed is very important. See, when you actually play some games, okay, there is something called as Chinese whisper. Okay, you say something in the ear of one person, and probably after a few years, the other person gets a complete different message. So while even if you say something, okay, even if you personally say something to the next person, this game demonstrates that there is a possibility, in spite of you saying something, the other person understands in different way, or you did not say loud enough for the person to understand. So the situation here is very, very similar. Whatever you write in your report, excuse me, whatever you write in your report, by default, it might not be understood by the other person, or you have used such language which other people would find very difficult, because the doctor's language can easily be understood by the doctor. But the one who is reading your report, who is not a doctor, what would they understand? That's very, very important for you to consider as to how to choose your language in your reports. But you have to use a simple language, but without compromising on the technical nomenclature. When I say technical nomenclature, for example, if you're using the word line quality, for example, so you cannot make simple about explanation of the word line quality in the case of handling examination. Line quality is a technical nomenclature. So you will have to use the technical nomenclature by default. But using such technical nomenclature, how you're going to show that what line quality actually means. You have to use your simple language there to say what it actually means by the line quality. So how line quality is going to be important in your observation. So this is the challenge which you have to face, and it's a challenging situation where whatever language, whatever understanding you have, so to make the other person to get the same understanding, so this requires a lot of language skills and diplomacy skills. So you have to ensure that your statement has only one and only one meaning. So if in case the statement would have different meanings, so your purpose of the conclusion will have no value. So for the same thing, I have given a last line here. One of the experts report, okay, which I have gone through, which I did the cross examination for. So which actually contains the statement like this. After all the observations, he writes, I hereby suspect the author being one and the same. Or, if in case I have to understand, it is highly suspicious that the author of both the writings being one and the same. So when you say I suspect, see, suspiciousness of the author being one and the same might be a negative suspiciousness or even the positive suspiciousness. Suspiciousness is like, I doubt. I doubt if I doubt that is the same person, or I doubt that is not the same person. That means you are not also very sure, and this can be interpreted by the respective advocates in their own way of presenting the case. This statement is not very sure. Okay, this suspiciousness, when you say I doubt, I suspect, being one and the same, that means it might be one and the same, or it might not even be one and the same. So this phrase, what the expert has used in this case, did not yield any good, need for the court to go with this conclusion. In the challenge, the presentation of your finding is always a challenge. Whenever the question arises, if the handwriting examination is a science or an art, so it's very important for us to understand that the examination aspects is science, but the way we present our report is an art. So this is where the art plays a very crucial role. To impress the judge with your finding is always an art. So in one of the fingerprint report, see, if you go by the fingerprint report standards, 8 point of similarity is very much required for a positive conclusion. That means it's an established fact that there should be at least 8 things in similarity to say that the fingerprint belongs to the same person. But one of the other principles also says one major dissimilarity is also sufficient for a negative conclusion. The question here is, what if you find only 6 points of similarities? Okay, what could be your conclusion? Can you give me this answer? People who want to comment on this, please raise your hands. What if in a case there is only 6 identical factors which you reported, but can you consider this as a positive identification, or can you consider this as a negative identification? What is it you want to do? People who want to, okay, they are chatting. Okay, it's a diplomatic opinion can be provided. Okay, fine. So I'll give you a real-time case, so you can just go through with the one of the judgment. It's very important judgment to be understood. So on the screen, you have a very important thing to read here. See, this judgment. Okay, this is a abstract of one of the judgment. Okay, in which I have I just gave an opinion, because in this particular case, I was able to find 6 similarities between the 2 fingerprints, but the fingerprints which were given to me was smudged. There is no possible way where I can actually give any further understanding about the fingerprint, but because of which I gave a report saying that there are 6 similarities. What the court says in the argument, this is like abstract from the judgment actually. In this judgment, the judge writes, it's an established principle that there should be at least 8 similar characteristics, okay, are to be shown for a positive conclusion. That is to conclude that the source of fingerprints being same. The commissioner appointed by the court and examined as EXC1 in his report at the conclusion has mentioned that it is highly probable that the fingerprints belong to the same person, to which the respondent took an objection that the opinion is not definite. Yes, as per the principle, It requires 8 things to be showing the positive identity. But applying the above established principles, I also agree that the opinion is not definite. But it is important to note that the commissioner in his report at the conclusion also have mentioned that I did not observe any dissimilarities between the fingerprints examined. So in my report, what I had reported as a conclusion is that, yes, I was only able to find 6 similarities, and it's a high probability that the person's fingerprint, is of the same source. But yet I am not sure because I was not able to show 8 as per the principles of fingerprint examination. But I also mentioned in my report saying that I not find any dissimilarities between the fingerprints, because of which, considering all the evidences which are presented before me, the commissioner's report corroborates the fact that the fingerprint belonged to the respondent, so and so. See, if in case I had only reported in the report that the fingerprint report does not belong, I mean, there are only 6 similarities, and it is highly possible that it belongs to the same person, on the best of the principles, my report would not have been considered. But when I mentioned I did not observe any dissimilarities, it is a very, very important thing to look at, because even one significant dissimilarity being sufficient to conclude that the fingerprint compared does not belong to the same source, on that principle, this statement was appropriately considered by the court of law. So when we write our report, we also need to understand the ultimate ground of your conclusion, whether your conclusion be of positive in nature or negative in nature. If in case you are giving a 50-50 kind of opinion, or it is not so definite, the sole purpose of your engagement in the case is defeated. Okay, there cannot be like, it may be belong to some person, it can belong to some person. This word has no value, because even the court or the litigants feel it might belong to the same person or it can belong to the same person. Because of that can or might be is only your role of engagement has a role. So for which it's very important for you to be definite in your conclusions. When we discuss about the handwriting opinions, the challenge will still be bigger, because for handwriting opinions, there has been no standards, okay? There has been no model which we actually follow, and every different laboratory writes every different categories of different styles of opinions. Okay, sometimes the laboratories just write a kind of essay. Some labs give a report which is just 1.5 pages. Even if there are 10 signatures, the report will be only for 1.5 2 pages. And there are also laboratories which also gives a kind of very good explanation about the whole finding. So this practice of report writing has not been set. When we discuss about the international practices, in the international practices, the boards like ASQDE or International Association of Document Examiners, so these kind of bodies have already set as to what are all the standards or what should be the reporting format. But in India, we don't have anything such that anything like that. So for which sometimes the report will have nothing except for the header when it came from some government laboratory, or there might be 10 pages which says a lot of unwanted things coming from some other laboratory, some other expert, which might be government or private. That's not the question here. So in the reports of handing opinions, the terminologies what we use is very, very critical, because we have to follow a standard set of the terminologies. If in case I refer something as movement, every one of other participant or every one of the other expert should know only one meaning for the term which I am using it as movement. When I say, okay, it's a free movement, there are a lot of reports which I keep on reading, okay, which actually mentions free movement. What is this free movement? Probably is not defined in any of the standard books or standard materials what we refer. Movement is of 4 categories: finger movement, wrist movement, whole arm movement, and forearm movement. So when this is the explanation of movement and what is movement is specifically defined, and there are some categories over there. What actually is meant by free movement is something which becomes a question over there. So the terminologies what we use in the reports, especially in handing opinions, need to be such that it is commonly understood, which gives the same meaning. You cannot bring in some, customized terminologies there. This is why I said the technical part has to be used appropriately. The nomenclature, the terminologies should never be compromised. When the question is asked about what a free movement is, the expert might give his own explanations. That is immaterial. But what actually is referred as a movement as per your books, okay, becomes a technical part of it. When you are asked, how do you explain the movement, that becomes the next question. But to mention with the same meaning of the movement is very, very important. Then the photographic demonstration, I just discussed about the photographic requirement for a handling opinion before this slide. So use appropriate degree of conclusion. We have been discussing about this. There are different degrees of conclusion based on the standards of the materials available to you, based on the category of the samples available to you, based on the quantity of samples available to you. The different degrees of conclusion would be chosen to conclude your opinions. When we discuss about the digital evidences and the reports of this category, so in the category of digital evidences, what happens is that you will be first given a source disk, okay, one particular file or one particular disk. When we do the examination, you submit the report, okay, but it is also important for you to submit 3 copies of the source disk, because in the code, when you submit, for example, one pen drive is submitted for examination. Police happen to seize a pen drive from a scene of crime, and that pen drive was examined by you, authenticated all the data which is in the pen drive. This pen drive is written back to the investigation officer, and that pen drive is now the evidence, and the files in the pen drive is the evidence. Now, how does the opposite person, who is the accused, will get a copy of the contents of the pen drive? How does he take a defense? How does the court access what is available in the pen drive? So can they access the evidence? When this becomes a question, it is important to submit in digital cases. 3 copies has to be submitted. One to the investigation officer and to the court. The same thing will serve. Second is the for one person that is a prosecution in the criminal cases, or in civil cases to the one party, and other report or the other copies for the opposite counsel. They should also get the same evidence what you have to take the necessary justification, or they should be given a provision to access those evidences against which they have been convicted for. So this is the principle of natural justice, and for this reason, as a forensic approach, we have to give 3 copies, okay, of our digital discs. Next is your findings, the source disk and file that has to be given in the copies. The report on hash value of the disk in your report. So when you submit a pen drive as a copy, or you have examined one hard disk of 1 TB, and what is evidence or what is important in the given case might be only for 10 GB or 12 GB or 16 GB data. When you choose to use that file and to give in a pen drive, you cannot just give the pen drive just like that. You have to also say what is the hash value of the files which are in that particular pen drive, and report in your findings. And that report should also contain the hash value of the pen drive. So tomorrow if somebody accesses a pen drive, they can also delete that, they can edit the content over there. So for which the hash value when you report in your printed report, that will act as a necessity in the digital evidence cases. And always avoid giving a CD or a DVD for any of your reports, because CD DVD can be broken. If you scratch the CD and DVD, it is not readable. Okay, I have experienced this kind of cases before the court. So when we submitted a CD as a disc containing some videographs, okay, and this disc, when I was cross-examined, when it was played, did not read, okay, and the judge was kind enough to understand the risks without having the CD or without even playing the video what is in the CD. How can evidence be established? For which the judge asked me the question, what are the possibilities that the CD will be unreadable? for which I had to answer. It might be because of scratches, it might be because of exposure to some other electromagnetic radiation. It would have been kept very close to the TV, fridge, or whatever it is. So all these things became the reason for the judge to consider, okay, submit another disk which contains the same video files the next hearing. So this provision was given. So because of that experience, I stopped giving CD or DVD for any of my reports. It's only the pen drives which could be encrypted and passwords, or the hash value can be mentioned in the reports. So when you ask me what's next, so whatever we discussed so far is the requirements of how and what you're going to mention in the report. But after this will be the cross-examination. So with this simple understanding, okay, I am now going to pose the audience to clarify any of the doubts, because I am hereby concluding my session, because cross-examination is a different topic of discussion, and we can discuss about that in the upcoming session. But so far, the aspects of reports and report writing has been discussed, and you can now pose the questions. And I am going to allow the participants to unmute themselves if in case they have to ask me the questions. So now the session is open for discussions and questions. Okay. One of the person asks the question, sir, is all the photographs compulsory in all the cases? The code of law, or in any of the previous judgments or water situation is, has never meant as to how many photographs are to be given, or if all the photographs are to be given or not. Whatever is necessary, you have to fulfill that. Whatever the photographs on which you have your findings, that is to be compulsorily given. But whenever you examine, it is also recommended you give the entire case, whatever you have examined, as a copy to the court, because this helps you in the cross-examination. Okay, see, it's not just about report writing, it's also about cross-examination. So when you give the entire case file to the court, so opposite party also has access to what data you have considered for the examination, based on which they're going to ask you the question. There's no difference in that. There's no wrong in that. So I have captured the photographs, I have did the examination, microscopic images, okay, examination under different conditions, and I have used those photographs which are necessary in my report. But for the purpose of examination, I have got many such photographs which I have considered for the purpose of examination. Not all the photographs you have used for examination need to be given in the report, but you can always give the report on which you have relied upon your findings. That is the answer for Ramya. And Purnima has a question. Diplomatic opinion can be provided? Yes. Diplomacy in the printed format, there is no diplomatic. You cannot be diplomatic in your conclusion. You have to be definite, whether yes or no. If yes, to what degree of your conclusion? If no, to what degree of your conclusion? But when you are asked some questions in the cross-examination, so there you can try to be diplomatic, and that is where your diplomacy skills will be of help. Otherwise, your report has to be very certain. How many characteristics should be matched in handing examination case to say that the handing is of the same person? Harshita, this question, the handwriting examination is not based on quantity. It is based on qualitative analysis. So there are, even if you find 3, 4, 5 good characteristics, that is sufficient. And there are also cases where, in spite of you mentioning several of the handwriting characteristics being same or different, whatever it is, still, okay, it might be considered as inadequate. So the handwriting examination is based on the quality, because with the principle that no two people write exactly alike. Okay, so every person's writing is going to be unique, and the writing being subconscious, and every person has a different style, different strokes to form. So with this understanding, when you say these two writings have found very similar writing characteristics, this is not about the numbers, this is about the quality. In case of two experts' opinion, which are contradicting to each other, which opinion will, which of the opinion will be considered? See, I just mentioned this. Whichever expert's report is very close to the facts of the given case, okay, circumstances of the given case, the court will consider that expert's report, okay, for the purpose of examination. How much procedure details should be explained in report? Is it necessary to include charts, Excel sheets, if any? See, you have to give whatever the information would reasonably convince the other person that your conclusion is proper. While you say your conclusion is proper, you have to give whatever is necessity as per your belief, your individual belief, that this finding would actually convince any person who don't know anything about the technicality of your subject. Okay, there is no rule which defines you have to give the charts, you have to give the Excel sheets, no. But it only defines reasonable understanding and reasonable convincing capability. When we say reasonable convincing capability, even for a layman, the judges are the laymen for this subject. Okay. However, they have the discretionary power to consider your report or not. But for a judge to understand on what basis you came to this conclusion, it is necessary for you to mention some of your findings over there. So I'm just going to share one of the reports, okay, which actually helps you to understand this particular thing. Because this is one such case where there were a lot of the documents were submitted before us, and the court asked us one simple question: what are the documents submitted to you? Which are all the genuine documents? So if you just look at it, I'm going to hide the court details here. This is a court case, okay? And if you observe the report standard, so which I maintain at my laboratory, okay, these are all something which we use for the purpose of the standard report writing. So in addition to various tools what we use, what is required for the purpose of demonstration in this report, I have also reported that. Because when I say I have scanned the photographs, scanned the documents, or taken the photograph of the documents, the question arises, is my observation was based on such photographed images, or my observation is based on the actual documents? So when this becomes a question, I have very clearly mentioned, though I have verified the documents using different tools, okay, and I have used these things for the purpose of demonstration in this report, which means I have used the scanner to scan certain documents and fingerprints to use it in my report here. Otherwise, my actual findings is given in a different disk. The document listed here, need for examination. What role is a primary assignment? That's why I said what purpose you are engaged will be actually requested by the court or by the investigation officer. In this case, they have actually asked us to examine every element of the document, marked as so and so, verify if it is genuine or fraudulent. That is the first question to answer. To examine signatures of so and so, if it is authored by same person or not. That is the second question. So they have defined everything here. And as per the court standard markings, they have usually marked the documents, but internally we refer these documents with a separate nomenclature. We might consider this as D, B, K, whatever series you want to consider it as. Okay. However, court has its own references, which we also have mentioned it here. When we come to the principles and practices of handling examination, okay, what I have mentioned here, this is very specific. In support of this forensic handling report, a list of most recognized texts on the subject are listed below, and all the principles employed in my examination and analysis are supported by these standards and publication. So here, I am not saying I have used this book theory or this book theory only, but I only say that my approach for this particular case is the result of the collective approach which is given in the materials listed below, and these materials are the most recommended readings in the particular field of question document examination. So principles on which my examination results are based on. Okay. However, in the first part is to ascertain which of the document is genuine which of the document is fraudulent, for which a lot of observation has to be done. Okay, so every element of every sheet, it contains around 16 sheets in total, but every sheet contains a rubber stamp, pen entry, pencil entry, printed content, stamp entry. So all those things are there. Okay, every element of every sheet has been reported in this particular finding. So if you look at page number one, okay, for example, page in all the pages, it is a stamp paper. In all the cases, the stamp paper is original. That means stamp paper is not color photocopied. But in sheet number one, okay, wherever they have written a mobile number, okay, the writing instrument what they have used is pencil in both the cases. Handwriting is same as this document, and I mean both the documents has got the same handwriting, and writing instrument in second entry in the first sheet. That means they have written something document number, and the writing instrument which has been used to write that in both the documents are different and different. So like this, every element of every sheet, when it is examined, this is necessary for the court to understand that because of these findings, I'll then conclude that both the documents are fraudulent or both the documents are genuine. This is important for the first part, whether the documents are genuine or fraudulent. To come to that conclusion, this is a part of the analysis stage where we have to report on every element and every aspect of it. So this completes the first part of it. Okay, after I examine all the 13 sheets in this case, okay, because of this many observation, my conclusion would be one-liner. Okay, my conclusion, okay, might be the documents examined so and so whatever. Okay, there are 3 different findings. Person who wrote so and so, the person who document number is same. Okay, the documents. So all these things becomes a part of my conclusion. But because of the findings what I reported in the beginning, the reasonings, because of the reasonings, I have a proper conclusion here. And those reasonings can be tested. If in case you use a microscope, I can still demonstrate to you whether if they have used a pen or it is a printed content over there. So that becomes a part of the report conclusion. So like this, I'm just demonstrating with you one particular signature verification report. But in different questions of the categories of the report, it is necessary you have to understand what is necessary according to the case requirement. It is not defined anywhere. It is not defined in any of the books. It is not defined in any of the case laws. It is you, the one who decides as to what is required in my case. Yeah. If a crime took place at 5 p.m. and one lady saw one person was going in the same building where the crime took place at 4:45, and there is no witness to that case, whether the testimony of individual be considered. See, the last scene theory, okay, the court of law in the recent days has also held that you cannot conclude only on the basis of last scene theory. This was important, provided the person who saw, person who went at that particular time, he also established the fact that they were actually not in good terms. This person had threatened that other person. This person was always waiting for an opportunity. So this might be the corroborative piece of evidence. Just because that the person was seen at that place at that time, it might not be the conclusive factor for convicting him. Okay, this also held by the recent Supreme Court judgment. So please go through that. He said there is no standard for handling reports. Is it same for all other types of evidence reports? No. See, different categories of reports has got different benchmarks. Suppose I'm discussing about the medical evidence. Suppose I give you a piece of a sample. I ask you, what does this sample contain? You do the examination and you come up with the result saying that this particular powder what you gave me is a brown sugar or a cocaine. This particular thing will only require the conclusion. Submitted powder, okay, after the examination is done, this is the it contains so much percentage of cocaine. Done. It doesn't require what is the complete procedure of chemical examination. It doesn't ask you for What did you do? First you took the powder, then you read what, then what did you observe, then flames, then this. It is not required. But only for few categories of evidences, it is the requirement which I am mentioning it to you. But different category of evidences has got different requirements before the code. And for technical part of it, people don't look at a lot of technicalities in this. Because of fingerprint and handwriting of these two categories, people think this is a very easy subjects to question, for which it is required for you to give suitable justification for your conclusions. Is scaling required for all the photographs? Yes. In the photography, whenever you're using it in the forensic part of it, it is a mandate that it is to be scaled only. Without the scaled images, that is not the recommended category of photograph to be used. If you're taking the photos of crime scenes at the time where there is no, if there is any noise or disturbance in photo, these photos has to be submitted to the court. The question is not complete, so I cannot answer this question. So if the photograph altered, then how can we come to conclusion based on only photographs, or how can we know the photograph altered? A photograph being altering is a separate category of a report because we discuss about the image forensics. Okay, the data integrity of the image can be tested, and there are different procedures for examination of the multimedia. When I say multimedia, images, audio, video, all these things comes under multimedia forensics. So every such sample has a procedure to follow for the purpose of examination and reporting of it. So because that's not relevant to the discussion here, I'll not elaborate on that, but there's a specific provision for examination of multimedia evidences, and every such tampering of any audio, video, and image can be ascertained by the forensic examination, and hence Section 65B of Indian Evidence Act is very, very important provision for authentication of electronic evidences. Can we say that EXA is similar to EXB than saying matched? Yes, this is where you will choose the right terminologies, because when I am of the opinion that when I say both the writings are not authored by the same person, it is for the court to consider, yes, it is an act of forgery. When I am very sure that this is an act of this category of forgery only, in some cases, I also try to mention this is because of this category of forgery only. So much so, when the question is asked to me, I'll be able to justify because of technicalities in that particular forgery. I can say the standard or general characteristics of forgery, which includes this characteristics, were observed in the signature. See, I can demonstrate the stain, the pencil stains here. I can demonstrate carbon stains here. Because of which I say this is a tracing method of forgery only. But in most of the cases, we'll see it depends on what questions you have been asked. Your answer should be proportionate to the question being asked. If the court asks you if exhibit A and exhibit B is similar, you have to say it is similar or not. When they ask you if both are matching or not, then you use the word matching. So this is where you're going to use the word as requested in the need for examination. All right. Is there a preference of testimonies of eyewitnesses over expert witness? If so, what if the eyewitness is bribed? Eyewitness is a direct witness, okay? But the expert witness, in most of the cases, has dominated the evidence of the eyewitness. When I say dominated, the court of law has a reason or has a responsibility or duty to go and give preference to the expert, because expert's opinion is not just an opinion, because as per Section 51 of Indian Evidence Act, when it said, this opinion of experts would be substantiated by reasonable technicalities and reasonable, the reasons can be given for that. But for eyewitness, you cannot give any reasons. I saw him murdering the person. Okay, I saw. That's a different thing. But as for the expert witness, when I say, this murder did not occur because of the shooting. Okay, I can clearly demonstrate that this murder happened because of smothering, because of you know, person was having the issue with the breathing, he died. When I say this with the justification, even if the eyewitness says, I saw this person shot him, whose report will be relied upon right now? Okay, so that's when it should always be understood that no evidence is better than anyone. Okay, the examination, the cross-examination is conducted, and it is a question of the credibility of the witness. The ordinary witness will also be called to the court. An expert will also be called to the court. They both will be cross-examined to the limited extent of their involvement in the case. So the expert's opinion is given a preference than the ordinary witness, because ordinary witness has no scientific backing of his statement except for the reason he was there. He saw it directly happening. But the expert witness has a a role to play, and for this you can actually refer to the observation of Rajiv Gandhi's assassination case. When Dr. Our director of FSL Chennai, Chandrasekharan, he actually gave an observation in his report that where was the human bomb when the human bomb approached Rajiv Gandhi? Where was the bomb tied? See, everybody knows that there was a bomb, but where was the bomb tied, and to what dimension it was bursted? When was it bursted? So all these things was clearly explained in his report. Okay, so for which, in spite of eyewitnesses said somebody came bursted, but expert opinion specifically said at what gesture it was bursted, because when he bent down it was bursted. So all these things are clearly mentioned in the expert's report. So in which direction, where and all the stains went. So all these things are clearly mentioned. So this is a very good example of how the experts finding will be suitable in spite of eyewitnesses. Sometimes eyewitnesses can be set aside when we have a reason to believe the expert is correct. When we are facing a doubt in the result of the examination, as expert opinion should be given without a doubtful manner, then in what way we need to give the opinion when there is actually a doubt. So when you have a doubt, you cannot form any kind of opinion, and you are not even obligated to give a definite opinion if you are not sure about anything. You have all the rights to say no opinion can be formed on the basis of the submitted evidences or submitted samples. You always can request the court to give more samples. You can always mention, okay, the report, the examination can be commenced upon the further correspondence in the court. So this is again a language what you're going to be using. Suppose when you have submitted 3 signatures, specimen signatures taken from the court, to examine with 5 signatures which are disputed in the court. Can 5 and 3 sufficient to examine? These 5 signatures belong to 10 years back, and today they are taking 3 signatures. And you can write back to the court saying that for the purpose of examination, okay, kindly submit any other additional documents, okay, which are dated 10 years before, or submit any other documents for us to commence the examination. Here, we don't actually mention from our laboratory, we don't mention that no examination is possible from 3 signatures or 5 signatures. We don't write that. We only write for the purpose of commencing the examination, we require additional samples. And if the court writes back to us saying that no additional samples are available in this case, the person is dead. Okay, so we then commence our examination, and then the degree of conclusion might vary. But otherwise, if in case I straight away say that 3 samples is not adequate to form the opinion, what if the person is dead? You cannot even get additional signature, and because you have said 3 signatures cannot be considered as a good sample size for examination. So what would happen then? Okay, so for which you have to see the consequences of your communication. You should also see the boundary at which you can work. So this is where you're going to be using your planning. See, here you are not favoring any of the party, but you're keeping the role, your role alive, and you are giving that reason that unless suitable samples are submitted to me, I can't even commence the examination. Okay, if in case you have provision, you give additional samples, or you say that no additional samples are available, I can then commence my examination. So you should have a reason to communicate back to the court. So this is where you have to be, communicating and be diplomatic in your approach. So okay, so I have taken up most of the questions from the chat box. So with this, I would like to conclude my session for the day here, because my aspect of today's discussion is only about how and why your report should be maintain a high standard. Because if you don't maintain your report in the required scientific standard, you're going to contribute for another court judgment which might say no reliance can be given on the opinion of the experts. So let's all change the practice of your report standards. So when we change our report standards, sorry, probably we can all see a better approach tomorrow. And when court will feel everybody are following good standard of report writing, court will then say yes, because we see a reason for the expert to maintain such kind of standards. The reports given by such experts can be reliable. So we need to contribute for this judgment going forward in future. But let's all gear up, for our report writing standards. So with this, I thank you all for the session here. So I'm going to Madonna.
Yes, sir. Yes, sir. I'm here.
You want to conclude the session formally?
Yes. Yes, sir. Yes, sir.
Yeah.
Good evening, everybody. It's my privilege to propose a vote of thanks for this session. Firstly, I thank Almighty for His blessings for the easygoing of the session. I, on my hearty vote of thanks to the Honorable Speaker for the 36 DHI Expert Talk, Mr. Faninder BN, Court Commission for Forensic Expert, and the Director of Clue for Evidence Foundation and Forensic Lab. Thank you, sir, for this informative session and as well as the dedication towards organizing such fruitful sessions. The topic, forensic report writing, standard practices, and legal significance covered all the areas of an effective forensic report writing, along with the significance of forensic report and and its importance, elements to be included in a forensic report, importance of photographs, simple court language for presenting the report, sections, provisions that defines the role of an expert and the report, handwriting opinions, duty of an expert, aspects of expert evidence, law law to maintain the good standard for forensic reports, digital evidences, and different case reports helped us to understand the topic in detail. I'm pretty sure that all the evidence would definitely benefit from this. Now, I'd like to thank all our participants for being a very patient audience. Last but not the least, I'd like to thank all our volunteers of Clue for Evidence Foundation for their hard work and support. Thank you once again, everybody. Looking forward for your kind participation in the upcoming seminars too. Thank you so much.